Hi, everyone. Welcome to HYLA's Arbitration 101 topic. Before I formally introduce our speaker and we kick things off, I do have a couple of housekeeping matters. Please note that this is a webinar, which means we cannot take you off mute. If you have a question or anything, please raise your hand using the chat function or the Q&A if you have a speaker question. Our speaker has asked to reserve questions until the end of the presentation, so we will go through those questions at the end. But please, as you have questions, feel free to drop them in the Q&A chat. Please remember to self-report your CLE on the State Bar of Texas website. I will be putting the course number in the chat about halfway through the program. But please respond, or please remember it is your responsibility to record your CLE credit on your Texas Bar page. We will be putting this program up on our YouTube channel, but please note that you only get credit for the CLE for watching it live. So if you watch it later, you will not be able to record your CLE credit. We have a few more people joining. Let's see. All right. We'll go ahead and get started. It's 12:06. So we are delighted to be joined today by Onyedebelu. I'm always going to ruin this. Onyedebelu.
Yes.
Sorry. She's going to be discussing Arbitration 101. She is a director of ADR services in the commercial division at the American Arbitration Association here in Houston. She is a trained arbitrator and mediator with expertise in strategic planning, program design, and facilitation. She excels at managing stakeholder relationships and delivering innovative dispute resolution solutions. She holds a master's in law from the University of Missouri-Columbia and is actively engaged in global ADR networks. So we are very, very happy to have her here to teach us all about arbitration. And with that, I will pass it over to Chi.
Thank you so much, Amber. So I'm Chi. My name is Chimdimma, but everyone calls me Chi. So please feel free to call me Chi. Hey, Amber, I think I want to go ahead and share, but it's not quite working. Okay, got it. Thank you. I'm gonna pull that up. Yes, Amber, can you see everything? Is that good?
Yes.
Okay, perfect. So I'm Chi. I'm a director of ADR services with the AAA in Houston. I do want to preface this by saying that when I say the AAA, I will be saying that a lot. I don't mean the American Automobile Association. It's the American Arbitration Association. That mix-up happens a lot. So I'm with the AAA here in our Houston office, and in my role, I administer our large, complex commercial caseload in the states of Louisiana, Mississippi, Alabama, and the city of Houston. I'm also a member of our national energy team, so I'm responsible for driving business development and promoting the use of our dispute resolution services in the energy industry. So I'll have my contact information at the end, just in case you have more questions or concerns you'd like to go over with me, then please contact me and I'd be happy to answer any questions. So this presentation on Arbitration 101 is really just to go into the fundamentals of arbitration. So I really like to thank Harriet, Amber, Lucy, and Katie with HYLA, and of course the HYLA leadership for this opportunity. I've been a member of HYLA for less than a year, and I was just telling Amber that when I usually interact with other members of HYLA, I either meet people that have experience in arbitration, are currently in arbitration themselves, have a faint understanding, or some that just really don't know what arbitration is, which is totally fine. But arbitration is a crucial dispute resolution mechanism. So I felt it will be necessary for everyone to at least understand how the process works. Because at some point in your career, even if you're not right now, at some point in your legal career, you will find yourself, like there's a very, very high likelihood you will be pulled into arbitration at some point. So it helps if you at least understand how the process works so you can give the best service to your clients. So going through this presentation, we'll just start with the fundamentals of arbitration, just really what really is arbitration. Then I'll take you through the arbitration roadmap. This is really just explaining the stages of arbitration. I broke it down into stages as to make it a little easier. The stages of arbitration and how the AAA administers arbitration. Then I'll give you some helpful tips on how to draft efficient dispute resolution clauses so you don't have any problems along the line. Then, of course, at the very end, we'll have some time for questions, answers, and of course, any comments that you have for me. So moving into arbitration, ADR in general is just dispute resolution outside of litigation. And arbitration is just one of those processes. So the cornerstone of ADR, like what ADR thrives on, is really that they're all typically private and confidential processes. So you've heard of arbitration, mediation, conciliation, expert determination, and so others. The cornerstone is really just privacy. But the difference with arbitration is you have the neutral third party who is known as the arbitrator, and they issue a binding decision, which is not called a judgment like we have in court, it's called an award. So in mediation, the mediator is essentially just a facilitator that's just really helping the parties move towards settlement. But in arbitration, the arbitrator goes a step further to actually issue a binding decision, which is known as the award. And typically you cannot appeal an award, but I'll get into that a little more deeply as we move along. So the types of arbitration is usually divided into two. We have like ad hoc arbitration and institutional arbitration. So with ad hoc arbitration, the parties manage the entire arbitration process themselves. So they determine the rules, the procedure, the logistics, everything through mutual agreement. So they have to agree to everything. So there is no third-party institution involved. Then, of course, if the event parties cannot agree on a procedural matter, then they seek the help of the arbitrator to arrive at that agreement. Now, with institutional arbitration, which is what we do here at the AAA, that's arbitration that's essentially conducted under the auspices of an arbitration institution. So like the American Arbitration Association and the ICDR. That's the International Center for Dispute Resolution, which is the international division of the AAA. So they administer all our caseloads that have an international component within the definition of the UNCITRAL model law. The ICDR handles our international caseload across all industries. At the AAA, we are divided by division: commercial, construction, employment, consumer, and so others. ICDR is just one big division that handles all of these international caseloads. So these institutions, like the AAA, we provide the rules, we provide administrative support, and we also provide a roster of qualified arbitrators. So the main difference between the two, between ad hoc and institutional, is that the institution is there sort of as a third party, like a middle person, just to really keep the process moving. So we are there to operate in the awkward area. We will handle billing for you with arbitrators, so you never have to discuss billing with your arbitrator. We will handle arbitrator disclosures. And of course, we'll help you make some administrative decisions when parties reach an impasse. So you're not spending more time trying to resolve a dispute within a dispute. That arbitral institution will make that decision for you. And of course, we have a roster of qualified arbitrators that you can pick from. I'm going to touch on just a few of the key differences between arbitration and litigation. As we've explained earlier, arbitration is typically a confidential process, same with all other ADR mechanisms. And it is largely informal. It is informal, but it is structured. And I'll walk you through that when we go into the roadmap. So it is very structured. There is a way arbitration is supposed to go, but it's mostly an informal, laid back vibe than what you would have in court. Then, of course, arbitration at its heart is intended to be economical and efficient. So you're not expected to have a whole wave of motions and heavy discovery. It is significantly limited to make sure we keep to that spirit of efficiency and keeping it economical. Then you will have a prompt final award from the arbitrator. I'm a lawyer. I never practice. I don't really know how long it takes. And I've never taken a case through the courts. But I know with arbitration, it usually is a lot quicker. So most arbitral institutions have it in their rules as to the timeline for when an award needs to be issued. So for instance, from the AAA, for most of our caseloads, it's 30 days. So from the moment the hearing is closed, the clock begins to count. So the arbitrator needs to issue that award within 30 days. For the ICDR, it's 60 days because that needs to be physically mailed to the parties. AAA domestic, we can really just send it by email. So everybody is really working hard to make sure we get those awards out in time, because failure to get an award out within the appropriate window is grounds for challenging. So that goes to finality and limited judicial review. So typically you cannot appeal an award, but you can challenge it on certain grounds, like say, was the award obtained through fraud or corruption? Did the arbitrator exceed the scope of their powers? Was there even a valid arbitration agreement? So those are grounds for challenging an award in court. So for appeals, the AAA does offer our optional appellate rules. So you can use this to quote unquote appeal an award. However, there are some limitations. Issues you can submit through our optional appellate rules are when they're determinations of fact that are clearly erroneous or an error of law that is really material to the dispute. but it moves on a really expedited schedule. And to use our optional appellate rules, you have to include it in your original arbitration agreement. And it moves like, say, within about 3 months, everything needs to be resolved. It's usually on the documents, except the panel, because for that process, you need 3 arbitrators. Except the panel requires that they require oral hearings, usually on the documents, it moves really quickly. Then, of course, with arbitration, it is a party-driven process. We say this a lot, and we really mean it. This process is yours. We're just here to make sure you get the best experience out of it. So you get to choose your arbitrator. You get to choose who's making this decision for you. And once you move into the arbitration roadmap, once we get to the stage of arbitrator selection, I'll spend some time talking about that and give you some tips on how to pick the most effective arbitrator for your case. Now, I would like to preface this by saying that this is just a median time frame. I will give you some like days, like how long you expect to spend within each stage, but it is a median time frame. So this is like the average lifetime of a case at the AAA. It can close earlier. It really depends on the parties and the arbitrator. And of course, it can last a little longer. It really depends, but on average, this is how long a case lasts at the American Arbitration Association. So at the AAA, the first stage is the filing and initiation stage. So at the AAA, typically the arbitration commences when one party, who is referred to as the claimant, files a demand for arbitration. Now, this demand at the AAA and also like most arbitral institutions around the world, we don't expect this to be it's not a formal pleading. It's really just like a 1 or 2 page form. We just need some basic information like who is representing the parties, who are the parties, are you asserting a claim, what is the locale, just some information just to get the case moving. It doesn't need to be anything too formal. Then as you're filing that demand, we need a copy of the arbitration provision within your contract. So something naming the AAA. So in your contract, when you get to your dispute resolution clause, it needs to say that this case will be submitted to arbitration administered by the American Arbitration Association, or for our international division by the ICDR. So we need that. Then, of course, we need the appropriate filing fee. Now, the filing fee is it's based on the claim or counterclaim you file. So I can't give you an exact figure. This is how much you pay in filing fee, but it really does depend. I don't want to get too deep into our fee schedule. But for each stage, I'll give you an idea of what you're expecting cost-wise, because a lot of people do say arbitration is expensive, but not really going to look into it. Is arbitration really expensive? So at the beginning stage, what you're looking at for whoever is filing a claim, whoever is filing a counterclaim, this is what you're going to be looking at cost-wise, is really the filing fee based on whatever your claim is. Now, once we receive this, the AAA will acknowledge receipt, will send you a letter. Our intake division will assign this to a case manager. We'll send you a letter acknowledging receipt of this demand, received your demand on this date. We'll be administering it under these rules. Then we'll give the respondent, that's the other side, a timeline to respond to the demand. So ideally, the claimant, that's whoever filed this demand with us, should have already informed the respondent, but we then give you time, okay, now respond, and do you intend to file a counterclaim? This is the time you now have to file this counterclaim. So usually you'll be looking like maybe about 15 days. Sometimes it can be a little quicker. But sometimes we're having trouble reaching the parties, it might be a little longer. So for our next stage, and I'm going to spend a little time here, for arbitrator selection is a very important part. So at this stage, we then come to the parties, lawyers, who know the dispute best. You know this case best. At this point, please advise us. What are you looking for in an arbitrator? What qualifications do you believe you need your arbitrator to possess to efficiently hear and determine this dispute? So at the AAA, we have like 3 ways of appointing an arbitrator mostly, and we really do expect parties to participate in this process. Because per our rules, if you do not participate, we will presume that you agree with everything that is going on and we will proceed with appointing an arbitrator. So the most common arbitrator selection process you'll hear from the AAA ICDR is the standard rank and strike. So at this point, parties have told us, okay, maybe I need an arbitrator that has experience in Bitcoin mining or something. Or you want an arbitrator that's licensed in a particular state or that's resident in a particular state. Say the locale is Houston. You want an arbitrator resident in Texas to keep down some cost. We will go into our roster, we'll do a thorough search, and we'll prepare a list of arbitrators that we believe are best suited to this case based on the criteria you provided us. So we will send this to you, and in these resumes, you have the names of the arbitrators, of course, where they're resident, their experience, if they're lawyers, some of their litigation experience, if they're industry professionals, like engineers, some of what they've worked on, an idea of what they do, have any professional affiliations, and of course, their rates. So you're not just picking the right subject matter expert for your case. You're also picking someone whose rates you are comfortable with, someone you believe you can afford. So if you want someone that maybe is $1,000 an hour, if we give you someone that's $6,000 an hour, at this point, you are free to strike them off the list. So you will then send you this list, send you their resumes, give you some time to review everything. We will always encourage parties at every time. Like even though arbitration is a little more adversarial when you compare it to other ADR processes, at every step of the process, we are encouraging you to collaborate. We will encourage parties to agree. Look at this list, tell us who you like, and let us know. We will invite them to serve. If parties cannot agree, because I mean, we are embroiled in a dispute right now. If they cannot agree, then we give you time to strike everyone you believe won't be a good fit, rank the rest in order of preference, and return it to us. So when you return it to your case manager, they will reconcile this list and appoint the most mutually agreeable arbitrator. Another way is to give you access to our roster. Now, this is our entire national roster. We'll give you limited access, of course, we're not giving it to you forever. We'll give you limited access to go in and conduct your own search. You should pick who you believe will be best. You know this dispute best. This is your case. Who do you think will be the best fit? You go in, pick, come back and let us know, especially when we're dealing with clauses where one party has to appoint one, the other has to appoint the other, then those two arbitrators will then appoint the third. At that point, we will give you a link. Go into our panel, pick who you believe will be the best arbitrator for this case. Let us know. We will invite them to serve. Then we have our direct appointments. Now, some of our caseloads, we don't really there's no time to go through a rank and strike process. For instance, under our rules, we allow for emergency measures of protection. So if you believe you need like a quick resolution to something, like not the merits of the case, but something that's part of the case, then at that point, per our commercial rules, for instance, we have 1 business day to appoint an arbitrator. So at this point, it's not feasible to go through the whole rank and strike or giving people access. So we will then take that step to directly appoint an emergency arbitrator to make sure we're able to give you the best service within that time frame. So cost-wise, at this stage, what you're looking at is nothing, really. You've already paid the initial filing fee to the AAA. No arbitrator has been appointed. Even when they've been appointed, they don't start incurring costs just yet. So at the arbitrator selection stage, there really is no cost at this point. And then next, we're going to move into our preliminary hearing. So if with institutional arbitration, at this point, the arbitral institution will sort of take a bit of a step back and let the arbitrator come forward to really run the arbitration as the process manager. So the preliminary hearing is usually the first meeting between the arbitrators and the parties. So the panel of arbitrators is 3, or if it's 1 arbitrator, just 1, and the parties. So usually it's via video conference. I mean, you will see some in-person preliminary hearings. I personally have seen some in ad hoc arbitrations. I can confidently tell you it's a needless expense. You can really accomplish what you need to accomplish via video conference. And of course, that keeps down cost. In person, if you're all from out of town, you have to travel, making your process even more expensive. So you can knock this out in a video conference, maybe an hour, 2 hours, it really depends. And it's at this preliminary hearing that the arbitrator and the parties really start digging deep into the procedural matters, the substantive issues, like the hearing dates. Do we need any conferences? We're talking about discovery. How do we handle communication? Everyone really has a different style to how they run their arbitration. So this is really, really get into it. So it's incredibly important that you participate at this stage of the process because so much will be agreed upon. Because from everything that is discussed during this preliminary hearing, then comes the scheduling order. In some jurisdictions, it's called a procedural timetable. Largely in the US, it's called the scheduling order. So this is essentially the timetable, like the framework for everything you've discussed, how this arbitration is going to run. So think of your scheduling order as the Bible of your entire arbitration. So it's very, very important you participate as counsel. We do invite you to bring your clients along if necessary, but usually you just see counsel involved. You have your calendars ready. Let's agree on dates. Let's agree on timelines. Will there be pre-hearing submissions? Are they necessary? Okay, let's put some deadlines. When do we have this? Are we even allowing motions at all? Okay, what is the procedure for filing a motion? So that's how we go into everything at the preliminary hearing. Then you have the scheduling order. So cost-wise, at this stage, of course, the arbitrator will be compensated for the time that they spend preparing for the preliminary hearing, usually just reviewing parties' filings, and the time that they spend actually conducting the preliminary hearing, then the time that they spend preparing the scheduling order. So once our scheduling order is ready, we send you the notice of hearing, everything is set, we have our hearing dates. The AAA will then go to the arbitrator. Okay, now you've met with the parties, you've talked, you have an idea of how this case is going to go, what's happening. How much do you think you need to take you through the end of the arbitration? Now, this is an estimate. They cannot give you this exactly how much because anything can happen throughout the life of the case. So this is an estimate. So, okay, with what we've discussed with parties, maybe we've agreed on 3 days of hearing. This is how much, this is how much. AAA will review this, then send this request to the parties requesting deposits. Now, remember, we are the middle third party. These fees that we are collecting is not for us. Deposits are for the arbitrator, and we're also a not-for-profit, so we do not take a portion of our arbitrator's fees. Whatever they request is solely for the arbitrators. We do not take any of that. So we are simply requesting this just to help, smoothen that process. So we will request the deposit. So that way you already know there are no surprises. You're not getting any surprise invoices like today, pay $20,000. You already know how much is going to be requested. And we will let you know if at any point the arbitrator decides that they need a little more money, it will give you a heads up. It won't spring it on you. So cost-wise, this is what you're looking at this stage, but to the AAA, there is nothing due. And after that, we move into our exchange and preparation phase. Now, this is usually the longest part. We've gone through initiation, we've picked our arbitrator, we've gotten our Bible ready for the scheduling order. Now let's start preparing for the hearing. We start building up to the evidentiary hearing. So parties start working based on the timelines that they have in that scheduling order that everyone agreed to. So you start to exchange information, you start to prepare, and more counsel begins to interact more. So I will say that the AAA, we've been around for about 100 years. This is the stage that parties usually settle. Because they're interacting more, they're seeing more of the discovery. And at every point, we encourage you to remain open to settlement. Like arbitration is just one avenue to effective dispute resolution. It's not the only option. So if you can settle in mediation along the way, we will congratulate you. We'll refund anything that we've not used, and we will wish you the very best in life. So at this point, the parties are now working together in preparation for the hearing. So as far as arbitrator involvement, is really just to address any challenges that arise during information sharing. Any issues that the parties can't resolve, the arbitrator will then have to step in. But there are some times that the parties are really able to collaborate and get along, and you don't really have much. Like all that the arbitrator really has to bill for at this stage is just reviewing the information. They really don't have to step in and do anything, because any point that you reach an impasse with opposing counsel, the best thing for you to do at that point is to either send an email or pick up the phone, get on a call with opposing counsel and try to resolve that issue. Because anytime you do not go to opposing counsel first to resolve the issue, the arbitrator has to get involved. And the arbitrator has to get involved, cost. The arbitrator has to bill for that time that they're spending to resolve these procedural matters. So we always encourage parties, counsel, collaborate. Like so many times the scheduling order is not set in stone. Unforeseen circumstances, you might have to reschedule things, maybe loss of life, God forbid, but some things happen, we have to move timelines. If you agree with the other side, just simply, we see emails coming all the time, like, dear arbitrator so-and-so, I've spoken with opposing counsel, and for whatever reason, I can't get this done by this due date. We've agreed to move it to this date. The arbitrator, more times than not, will agree. Once parties have reached an agreement, they say, okay, no problem, issue an updated scheduling order, keep it moving. But if the arbitrator has to get involved and start reviewing motions and starts having calls with the parties, you are incurring more cost. So at this stage, it really depends on the parties, depends on counsel. So anytime you need the arbitrator to intervene, they will bill for it. And of course, if there are pre-hearing submissions, the arbitrator will also bill for time that they spend reviewing these submissions. So this is usually the longest part of the process. Now we're at the evidentiary hearing. This is what we've been building to. This is what we've been building up to, the evidentiary hearing. Now this can last from anytime from a single day to 2 weeks. It really depends on how much time the parties believe they need to present this evidence and testimony to the panel or the arbitrator, and how much time the arbitrator also believes is necessary. If parties are asking for a 1-month hearing and the arbitrator believes that, no, this is too much time, of course, they will not agree to it. But this really depends on the parties and the arbitrator at this point. So cost-wise, of course, the arbitrator will be compensated for the time that they spend in the hearings. Each hearing day is usually about 8 hours with maybe an hour of a break snuck in somewhere. Then, of course, the time that they spend reviewing the evidence and any reasonable expenses. So say mileage, tolls, if they bill for it. Then, of course, if you're having an arbitrator coming from out of town or out of the country, they do have to pay for their travel. So their flight, their accommodation, so every expense. But we are very transparent with billing. We insist upon it because we are here to make sure the parties have the best experience. So we will let you know this is how much the arbitrator has spent. This is how much it is. This is how much we are paying them. And at any point, you're also welcome to ask, like, how much do we have on hand? Is there anything else we need to pay? Do we have any pending invoices for the arbitrator? Then on the administrative side, there is a final fee that is due before the hearing, before parties go to hearing. So we have two administrative fees. The initial one that you pay at the beginning when you're filing your demand, and this final one. This again is also assessed based on the claim amount, and it is only payable if you actually proceed to hearing. So if you settle during that exchange phase and you let us know within time, you will refund your final fee and wish you all the very best. So this is payable if you actually proceed to a hearing. So these are the only two times you have to pay a filing fee. The rest is compensation for the arbitrator and also for their expenses. Now we have the post-hearing submission stage. Now, sometimes this isn't always necessary. There are some times when the parties believe at the end of the hearing that, okay, we need additional briefing. The arbitrator needs to review additional documentation before they, issue the award. And if the arbitrator allows it, the arbitrator will then set a briefing schedule. Now, this is usually concluded just shortly after the hearing. So maybe within 30 days or 21 days, they'll set a deadline for parties to file their post-hearing submissions. Then, of course, some extra time for any replies. So after the hearing, because the AAA is not present at the evidentiary hearing, so after the hearing, we will contact the arbitrator like, we noticed that the hearing was scheduled from this day to this day. It is now over. Do we have your permission to close the hearing? Will there be any post-hearing submissions? So if there are, we do not formally close the hearing. Because once we close that hearing, if you remember the timeline I talked about earlier, that clock begins to run. So for instance, for a large complex commercial case, if we close that hearing, that 30-day timeline that the arbitrator has to send out that award begins to click. So we do not close the hearing until the final post-hearing brief is in. So once all the briefing is in, we will write to parties and the arbitrator that, okay, now the hearing is officially closed. Expect an award on or before so-and-so date. That's whatever timeline it is. So at this point, nothing else is expected. So cost-wise, of course, compensation for the arbitrator for any time they spend reviewing evidence and also the post-hearing submissions. So if there won't be post-hearing submissions, they're not billing anything about post-hearing. There's no cost at this stage. But to the AAA, there's no financial implication. So now the final stage, the award. So now, say there are post-hearing submissions, we've received all the briefing, we've closed the hearing, arbitrator has 30 days for most of our caseloads. For some, like our expedited caseload, commercial-wise, as for cases that are less than $100,000, they have 14 days. But for most of our cases, you have 30 days. For the ICDR, you have 60 days. It begins to count. So ideally, from an administrative standpoint, we usually ask the arbitrator to send us this award ahead of time, maybe by day 20 or so, because we need some time to review it. Now, not to re-argue any party's points, not to redetermine the facts, is solely to look out for any maybe formatting errors, typographical errors, anything that just look a little, we're not quite sure. That's really just to look at it. Any computational errors, any typographical, that's what we're really looking out for and reviewing that award. So we need a little time to do it. So if say maybe because at the awards part, that's when you hear the common phrase in arbitration that costs follow the event in arbitration. So that really means it's a fundamental principle in arbitration. It essentially means that the unsuccessful party now has to pay the successful party all administrative fees and any legal costs, so like attorney's fees. So everything that you have billed your client in attorney's fees, you would put this in. If you have post-hearing submissions, you put that in. That comes in. The arbitrator will then assess this. So we can tell the other side, okay, or you then have to pay the successful party all of this. So from the AAA standpoint, we need to make sure that the figures in terms of our administrative fees are right. Because I must tell you, and please, 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 please remember that once that award is issued, it is final as to the merits. There is nothing to change. So if you make a mistake and in your attorney's fees and you ask for less, maybe you leave out $60,000 by error, it is gone. You are not getting that money. Once that final award is issued, if that correct figure is not included, it's done. So from the AAA standpoint, we need to make sure that the right administrative fees are included, the right figure, so that whatever successful party gets what is owed to them. So that's what we're just really looking at. Then we send the award to the parties. Now, once this award is done, is gone out, the arbitrator has discharged their duty as arbitrator. Unless we have any like last final little administrative issues we need to deal with, our services are also done. We sent this out. We wish you all the very best. Please let us know if you need us again. Now, we do have a small window of time that we allow for modification of the award. Again, this is not to redetermine the facts, not to re-argue the issues. It's really just to maybe interpret the award. If there's a word the arbitrator used, you're not quite sure, you understand, you can reach out. We give you commercial rules. Large cases, we give you 20 days, 20 calendar days, not business days, calendar days. So review the award, something you don't quite understand, let us know. We will contact the arbitrator. The arbitrator can then clarify it. Or if there are still errors, typographical errors or computational errors that you got right in your submissions, but you believe that we just didn't catch, you can let us know. We'll give the other side some time to respond. Then we'll let the arbitrator know. We give the arbitrator really like a short turnaround time, I think about 20 calendar days as well. So that way we can make sure parties get their award quick and also move on with their lives as well. So that's the only time we can actually apply to like review an award, but it cannot be appealed. Nothing can be changed. It's really just slight things that can easily be fixed. So at this point, the arbitrator is just compensated for drafting the award. Any unused deposits, sometimes we do have surplus, because remember, every deposit we requested is simply an estimate. So anything we haven't used, we will give you a full detailed financial reconciliation. This is how much we billed. This is how much you paid when you paid it. This is what was dispersed. When we dispersed it, this is how much is left over. We're giving it back. Advise us who you want us to pay it to. So anything that's unused, we pay. And if for any reason there are fees that are still due, we will continue to follow up to make sure we get those fees in. But anything unused, we'll return it, and thank you very much for working with us. That's really how the AAA administers arbitration, and usually maybe 288 days average life of a case. So next, I'm going to give you a couple of tips on effective clause drafting now. We can spend an entire hour talking about dysfunctional clause drafting, but we don't have an entire hour, so we're not going to do that. So I'm just going to touch on a couple of points just to help you, and I'll provide some resources that you can also use in your practice when you're drafting effective dispute resolution clauses. So when you're drafting the piece, the first thing I have in your mind, do not use a one-size-fits-all. If you go on the internet, you will see several sample dispute resolution clauses, which are all great, but the intention is not really for you to just copy paste. Always make sure you're tailoring these clauses to your contract. You know your business best, you know your clients best, you know your industry best, you know your needs best. So make sure you're tailoring this clause to serve you. Do not just copy paste. Consider the nature of the agreement. Like, one, is this dispute even appropriate for arbitration? Is it best suited to arbitration? Then consider the location. Make sure you're picking a place that works for everyone. For instance, because once it's in, it's in. Unless the parties agree to change the locale later, that's the location of the arbitration, it's done. You can't change it. So say counsel for the claimant is in Washington, D.C., counsel for the respondent is in New York, the parties are in Pennsylvania. Why is your locale Corsicana, Texas? Because now you're locked in. You cannot change that unless you agree subsequently to change. And at that point, you're already embroiled in an existing dispute. The last thing you want is to start trying to resolve another dispute inside the dispute, because this wastes time, this costs money. So now you all have to travel to Corsicana and God help you, you pick an arbitrator that is in the state of Washington. Everybody is now flying into Corsicana, so that is more expense. So pick a location that works, that's feasible for everyone. Sometimes we do see cases in our cases every day. Sometimes parties are able to agree to change the location. A lot of times they're not able to agree. So then they have to go to this place that's so expensive for everyone. Then a tiered dispute resolution is really just like a multi-step dispute resolution clause. So say before you come to arbitration, try negotiation, try conciliation, try mediation, and we encourage you. Please consider a multi-step dispute resolution clause if that works best for your business. Again, arbitration is not the only avenue to effective dispute resolution. There are other ADR processes that you can try and also work better for you, that work very well. So you can also try mediation. Should they try mediation first? But what I will advise you is if you're going to include pre-steps to arbitration, please put a timeline on it. Because the last thing you want is for it to be open-ended. Parties should mediate. If they cannot reach a resolution, they should go to arbitration. At what point do you decide that parties have not reached a resolution? Then you're stuck. So if you're going to try have parties mediate before coming to arbitration, put a clock on it. 30 days, 60 days, 90 days. Let it be definite. So you ensure that the process keeps moving. So if 60 days hits, you haven't reached a resolution, you move to arbitration. Then always consider the types of dispute likely to arise. Because what this does, if it gives you a sense of what types of issues that will be subject to arbitration along the line. So that way you can now consider, for instance, what rules should I use? You know the type of disputes that will likely arise. What types of rules should I use? Which arbitral institution will be best suited to my case? We do have some specialized arbitral institutions that are solely for disputes in a particular industry. At the AAA, we cover a wide array of industries. Pretty much everything you're looking for, we cover it. Some are very specialized. So if you pick the wrong arbitral institution, the rules don't work best for you, you're stuck unless you can agree at that point. So for instance, maybe it's in the energy industry, you can say, okay, the AAA has a very solid energy panel. I'll write in the AAA rules for that reason. They have good administrative support. So start thinking of that early on. Your arbitration, it really starts from your clause. Like take it all the way back to your arbitration agreement and make sure everything is tidy. Do not create problems for your future self. Then consider the potential amount in controversy. I've seen some clauses that say if the total claim and counterclaim amount is less than $5 million, we'll have a single arbitrator. You're controlling your cost. You're making logistics easier because now when you get to the preliminary hearing, you're not just looking at one arbitrator's calendar, not three. Sometimes that can be tricky to coordinate. Then they said if the amount in controversy is over 5 million, we'll have a panel of 3 arbitrators. Because you might think that, oh no, it's just probably going to be, you're looking at large issues to come from this. And you stick in a panel of 3 arbitrators and you're hit with like a $50,000 claim. Now you have to pay 3 people. And if the other side doesn't agree to modify this to make it 1, you're going to pay 3 people. The amount in dispute is like, let's say $50,000. What you will likely pay those 3 arbitrators will probably be more than the amount in dispute. So don't try to mousetrap the other party. Think of yourself. At that point, you can't change it. Administratively, there's nothing we can do. And there's no arbitrator that will try to change that on their own because they need to protect the integrity of their award. If anything they change, that means they're exceeding the scope of their authorities, which is grounds for being challenged. Let me just run through a couple of quick options, something we've been around for almost 100 years. We've seen several kinds of clauses, several types of options within. So let me give you some points, things that you can consider to include in your contracts. Of course, very important, the arbitration rules. Unless you want this arbitration to be ad hoc, you can include arbitration rules, which will agree that this institution will administer this arbitration for you. Now, governing law is also important to consider because what the governing law does is it helps you identify what law will apply to, say, interpret and enforce the arbitration agreement itself. So if there are disputes around the arbitration process, what law would apply to interpret this and also enforce it? Then, of course, your locale. Very important, consider your locale. If parties are in different places, you can pick a neutral venue, but please pick a location that makes sense for everyone. If you're going international, you will hear more of like the place of the dispute, the seat of the arbitration. That's a whole different thing. In international arbitration, the place is really just the physical location of the arbitration. So say the place of the dispute is Houston, Texas. Then the seat is the governing law. That's the legal framework that will apply. So not just the arbitration, but also the award. So you can say the seat is Paris, but the physical location, the actual arbitration, the hearing will be conducted in Houston, Texas. So that's international. With domestic, it's really just with the locale. Then arbitrator selection. Do you want to talk about the process of arbitrator selection? Some parties would like to include qualifications in their clause. I want whoever is going to serve as an arbitrator should be either a lawyer, a professor, an industry expert, whoever that has over 20 years of experience in the energy industry. That's what you have in your clause. So once that time comes, we'll look for him. Now, specificity is good. Over specificity can be a problem. So do not get too specific when it comes to putting things in your clauses. For instance, the person must be resident in Waco, Texas. Are you sure about that? What if you cannot find an arbitrator that has 20 years of experience in the energy industry, resident in Waco, Texas? Now you're stuck. You're trying to work out with the other party. Okay, let's agree to modify this. So also be very careful with when you're drafting your clauses. Then confidentiality, even though I've said earlier that the cornerstone of ADR is privacy and arbitration is typically a confidential process. If you're going ad hoc, I will encourage you to include this in your clause. If you're going with an arbitral institution, most institutions have it written into their rules, like the AAA is written into our rules. We impose confidentiality by default. This will be a confidential process. Once you get to the preliminary hearing, the arbitrator will discuss it again with you. This is going to be a confidential process. You can go into like ESI protocols, how to handle information, but it is confidential. Some institutions do not. So always consider that. If you're going with an institution that does not impose confidentiality, you should definitely write that in. Then discovery. Sometimes parties want to limit discovery, maybe 5 depositions per parties, or even want to talk about the hearing, a half day of hearing. Are you sure? Because you're thinking that, okay, nothing serious is going to come from this. Then next you're hit with like a $500 million claim. Out of nowhere, you did not expect it, and you are stuck with 5 depositions, or you are stuck with a half day of hearing. Unless the other side agrees to modify that, that is it. You will have 5 depositions, you will have a half day of hearing. I said earlier, the arbitrator will not change this without party agreement because they want to protect the integrity of their award. And of course, any remedies with the AAA, we have it in our rules, emergency relief. That's for our emergency cases. It's written into our rules. So you can just apply for it. But sometimes you're with institutions that don't have it written into their rules. The ICDR was the first institution to introduce emergency measures of protection in the international space. So some institutions don't have it. So if you want that to be considered, you can also write that into your contract. Attorney's fees and costs. Like I told you earlier, by default, if it's not clear, we will just split it 50-50 for most of our caseloads. I believe with employment and labor, it can be a little different, but for like commercial construction, we will split it 50-50. So if for any reason you want that to be different, you can write that into your contract. And the type of award is a standard award, which is really just, this is what happened, this is a review, this is the decision. But you want a reasoned award. For domestic, most times you will see, like in domestic clauses, you will see either the standard or the reasoned. In international, it's really best practice to have a reasoned award. So a reasoned award is really just a little more information, just a little more explanation of the arbitrator's reasoning, but without a full explanation of the facts. It won't be a whole epistle, but a little more than that. This is the decision. Some explanations behind the reasoning. There's like a summary. So it's a little longer. It takes a little more time. So of course, it takes a little more time. They will incur a little more cost in drafting this award. So these are just some options that you can consider in drafting an award. Drafting your clause, sorry. So of course, I mentioned dysfunctional clause. We see these clauses all the time. We see problematic clauses, and unfortunately, administratively, our hands are tied. There's nothing we can do. So once you have a poorly drafted arbitration clause, it just taints. It has the potential to taint the entire process. Because one, arbitration then fails to meet your expectations. You're frustrated every step of the way. You're not happy. Administratively, the AAA can't do anything. So as you're trying to argue some of these things, trying to change, trying to talk to the party, let's modify this, let's waive this. There are delays, inefficiencies, taking longer. Sometimes you might even have to go to court to interpret something in the arbitration agreement because it was just too vague. And at the end of the day, this all leads to arbitration being blamed from this unfortunate experience. Not the clause. Is then I don't like arbitration. Not that I had a poor clause and it led to a poor experience in my arbitration. So like I said, we've been around for almost 100 years. We've seen this. So if you are working on a clause for your contract that names the AAA or the ICDR, please feel free to reach out to us. We will never, ever, ever give you legal advice. But we can help, we can answer some questions. Like, for instance, maybe you want to write in the optional appellate rules. Come to us. We will explain how it works. We'll tell you what you need to do, how exactly it works. We're not going to give you legal advice, but we can put some things in perspective for you. And of course, we're a not-for-profit. We will do this at absolutely no cost. We just really want you to have the best experience in arbitration as possible. Let me just give you a few tips, practical tips on how you can control time and cost in arbitration. So we've talked about this. Pay attention to your arbitration clause. This is where everything starts. Make sure you have the right information in. Make sure you have the right thing that works for you, works for your party, works for your industry. Do not create future problems for your future self. Because there's a common joke that, oh, when lawyers are drafting contracts, it's almost midnight, it's 11:30, you're like, oh no, I haven't put in the clause, a dispute resolution clause. You go online, you Google, you take something, you paste it in. And sometimes we see them, you can tell that this clause was copy pasted. It's a different font, it's a different font size, you need to know. Much time wasn't really put into this. 2-3 years down the line, you have a dispute, you're stuck with that clause you didn't really think about. So really, really pay attention to your arbitration clause. Then select attorneys experienced in arbitration. I understand I'm likely talking to a room of attorneys. I am also a lawyer, so I do not mean any disrespect, but there are times the problem is from the lawyers, not because they're bad at their jobs, but simply because they are not familiar with arbitration, they don't understand it, and they're not willing to ask questions. The good thing with institutional arbitration is you can always ask your case manager, not for legal advice. We're not going to tell you what to do, but we can explain the process. What next? Okay, this is what happened next. At this point, you can do this. In arbitration, you're not allowed to do this. You're allowed to do this. So pick people that are experienced in arbitration. So by sitting in this presentation, you are gaining this experience that you need. So once you find yourself in arbitration, you really know what to do. Then be mindful of deposits. Remember, we sent you an estimate of what the arbitrator believes that they need to take them through the case. So you know how much you've paid. So be mindful. If you keep filing motions, if you keep requiring the arbitrator's attention, that pool of money that we have is going to keep reducing. So at some point, you start getting invoices. We need more. So once there's an issue, please speak to opposing counsel. Speak to the other side first. Try to resolve the dispute on your own. Collaborate at every point, every stage of the process. Be sure to collaborate with opposing counsel. Anytime you cannot agree, the arbitrator gets involved, cost. So limit discovery to what is essential, because the more you file, the more bulky it is, the more they have to read, the more time they spend on it. Limit motion practice. There are even some arbitrators that don't even encourage motions. They don't like it. They don't allow it. If there's an issue, they would rather get on a call, a 1-hour call with the AAA and the parties. Let's talk about this. Let's resolve it. Instead of one side filing a motion, the time that you prepare, because you are also spending your time. This is not the only case you're working on. You're spending your time to file this document. You're filing it, you're billing your client. You're sending the other side will review it, file. The arbitrator will then review all of this before issuing an order. They would rather spend an hour to talk to the parties and resolve this than spend maybe 3-4 hours of time for all this back and forth motion. So limit that to what is absolutely necessary. And then choose an arbitrator with experience. You remember, this is a party-driven process. You have full control over who is going to hear this dispute. Do not just pick somebody you admire. Do not just pick a role model. Pick someone with actual industry experience, actual subject matter experience. Go to every institution. They have the people. If you come to the AAA, you want someone experienced in construction. We have a whole construction panel. We can give you energy. We have it. Healthcare. We have it. So pick someone with actual experience. Then trust the arbitrator. These are people that have been vetted. These are practicing experts, practicing professionals. They know what they're doing. Trust the expertise of the arbitrator. Every time you spend, all time that you spend challenging every decision of the arbitrator, you're not only incurring more time, it's more cost. And of course, remain open to settlement every stage of the process. Like I said earlier, a lot of our cases settle at the discovery stage, a lot, because you're communicating, you're open to settlement. And we encourage it, we're happy for you. Like sometimes we will even administer a mediation concurrently with the arbitration. Like a lot of parties believe that you have to stay arbitration to be able to mediate. That is not true. So they're worried, rather not put this arbitration on hold, than spend time and money mediating. Let's just continue with this. And we will tell them, no, you can do it concurrently. Even with the AAA, we have a panel of mediators. If you want to mediate outside the AAA, that is also fine. You can do this concurrently. So if at some point you reach a settlement mediation, all we ask is that you let us know. So we will inform the arbitrators so they can stop. So they don't keep incurring costs. So they can stop. We will let parties know. We will refund anything that needs to be refunded and wish you the very best. So the preliminary hearing, very important what we have, where that scheduling order comes from. Participate fully, then present your case efficiently. Anytime you don't come with your very best, you're not prepared, sorry, you end up with something that you can't really change later. For instance, you don't review your calendar before the preliminary hearing. You agree on a date, then a month later you realize that, oh God, I had a vacation scheduled for that time, or I have another hearing, I have somewhere I have to be, I have a surgery. Now you're going to spend time telling the other side, can we change this? And what if the arbitrator no longer has availability for that year? That then kicks the hearing into the following year. This is causing delays that could have been avoided if you had prepared ahead of time. Or if you come to a hearing, you're not ready, like come to a preliminary hearing, you're not ready for this hearing. And say the hearing was scheduled for an hour. 20 minutes in, the arbitrators realize that we simply don't have enough to keep going. So they reschedule the preliminary hearing, maybe give you another month. Go file a substantive claim, go back, work on your briefings, come back, let's start again. Or you say, I haven't spoken to my client. I don't know when they'll be available for a final hearing. You're not ready. You've rescheduled the hearing. Now, best believe that 20, 30 minutes that they spent in that initial call, they will bill for it. And it might seem like a minor expense, but if you keep doing this, it adds up. And you're not just paying, sometimes you're not just paying one person, you're paying three. So they will bill for this. So here's some practical tips that you can use to control cost and time on your own in arbitration. And at this point, I really want to plug in this tool that we have. It's a free resource from the AAA ICDR. It's called our Clause Builder AI. It's still in beta form, where it really is just an AI chatbot that uses AI language models to draft a AAA ICDR arbitration clause for your contract. So it won't draft for another institution. You can always modify that if necessary, but it drafts based on our rules. So it's free to use. Just put in your email address and start using it. Now, disclaimer, do not just copy paste. If you must copy paste, please read it. Always tailor it to what is best for you. These are really just templates to give you to work off of. So it can give you proper templates according to our rules. So it gives you some options like number of arbitrators, governing law, locale if you want to specify. It gives you some options, things that you keep on your tips of your finger when you're drafting. But this is for you to use. It's free. So please, I encourage you to take advantage of it. Then just finally, before we end, I do want to mention that the AAA ICDR has a foundation. If there's nothing you remember from today, please remember this. And through our foundation, it's really just our charitable arm where we give back to the ADR community. Since 2015, since it was established, we funded grants worth over $8 million, and we really want to keep doing more. As long as it's related to these three priorities to prevent and reduce violence, bridge community conflict, and support DEI, we will support it. This has to be related to dispute resolution. We also have scholarship grants. So if you want to learn more about ADR, you want to attend conferences, you want to take courses, but you just can't quite afford it, that's okay. You can please come to us. We will definitely consider it. So you can always visit our website at the bottom if you want more information, or if you have maybe an organization that you work with that you believe is in this right field and will benefit from a grant, please, I'll have my information at the end. You can reach out to me and I'll connect you with the appropriate person to speak to. We would absolutely love to fund a project in Houston this year. So please, this is very important. I really felt it was necessary to mention this helpful resource. So thank you so much for staying with me through this like 50-ish minutes. And we can just take whatever questions that you have at this time.
Thank you so much, Chi. We do have a question. It says, what if I have a question about a case I have in arbitration? Can I contact the case manager to ask questions, or is that off limits?
Okay. So when it comes to questions about a case you have in arbitration with the AAA, please contact your case manager. You cannot have ex parte communication with the arbitrator. The other side and the AAA must be copied. But if it's simply like an administrative issue or you just want guidance on how to do something, please reach out to your case manager. They're always there to help. But it has to be your case manager. Anyone else doesn't have access to their cases for privacy reasons. Only the case manager can see it.
And then I have a question. So I've been in a couple arbitrations now, and I'm always interested to see the difference in pricing of an arbitrator. Does the more expensive the arbitrator necessarily mean the most experience? You know, some arbitrators are $250 an hour, some are $500 an hour. So does that equate to experience, or how do they pick their pricing?
So not necessarily. So everyone has their pricing. Like, of course, sometimes it's location based. Texas arbitrators are usually a little less expensive than, say, New York or California. The standard of living is just different. So sometimes it's location based, but it doesn't necessarily mean this more expensive person has more experience. For whatever reasons, is their personal preference. We don't have any control over how much they bill because we don't take any portion. So sometimes also from their law firms, their lawyers, some of their law firms don't allow them to go less than a certain amount. So if they're billing maybe $1,200, is because their firm doesn't really allow them to go less. So you will get excellent service. We thoroughly vet our panelists. So you will get excellent service with someone that's charging $300. The same we get with someone that's charging $6,000. So it really just depends on picking what is best for you. Great. Thank you, everyone.
Thank you. I don't see any other questions. You know, I would like to thank Chi again for this lovely presentation on arbitration. It was very informative, and we really thank you for giving us your time and educating these our HYLA membership. Please, everyone, remember to go report your CLE. The number is in the chat, but if you need me to read it out, I will. It is 174-24-8274. And with that, we hope to see you next month. Next month, our CLE is going to be over what I wish I knew in my first trial. So it was very nice. We had some ADR conversations today. Next month, we're going to talk about, you know, tips and tricks on your first trial. So we hope you'll also come to that. Keep an eye out on the HYLA calendar for that date. I don't want to give you the wrong date. I don't have it in front of me at this moment, but it is in our HYLA newsletter. You can find the date for that next CLE in February.
Thank you so much. Thank you, Amber. This is a great opportunity. Thank you so much. And please contact me with any questions or concerns. We're always happy to talk to you guys about ADR. We love arbitration.
Thank you so much, Chi. Everyone have a great day.